When can a school dismiss a teacher for good or just cause? What happens when a teacher's iPhone with some, let's say, risque photos automatically syncs with his district-issued iPad? What could possibly go wrong?
Nothing. Nothing could go wrong, Chris.
Nope. No. Definitely not a case about it.
No. And, well, if we're talking about it, then lots of stuff went wrong.
Unfortunately, that's just kind of the nature of our show.
This is what we do. It's what we do. Okay, so really interesting case here today, folks. We've got a teacher who took some, naughty pictures on his iPhone. It was his personal iPhone, but it happened to be synced to a school-issued device. The proverbial cat got out of the bag, and he was reported to Child Protective Services, who then called school officials, and we are going to dig in to how all of this played out as we cover the case of Board of Trustees of Lincoln County School District Number 2 versus Erling.
It's a nice, simple case name.
Yeah, exactly.
Rolls off the tongue.
It does. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education, one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. And now Jamie and I are both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Welcome back, everyone. Before we jump into our bell ringer, just want to remind everyone to please like, rate, review Chalk and Gavel wherever you get your podcasts. If you're watching this on YouTube, please smash that like and subscribe button. Is that what people say?
I guess.
I don't know. We're new to this video thing. But if you could continue to help us spread the word about Chalk and Gavel, we would be so grateful. Tell a friend, tell a colleague, whoever you want to share the word with. You can also go to our website, chalkandgavel.com, where you can find our teaching guide as well as a feedback form if you want to get in touch with us. You can also find us on social media at Chalk and Gavel, or you can find us on patreon.com/chalkandgavel if you want to become a friend of the show. And for the low price of just $2 a month, you can help support Jamie and I as we continue to make this content and promote this show that we really enjoy making.
Absolutely. Yeah.
With all that, Jamie, I think you have a bell ringer for us.
Well, yeah. I mean, we could probably do this show every single day and have a new bell ringer.
It seems that way, right? The fire hose has not...
It hasn't let up.
No one's turned it off.
We've talked a lot over the last few episodes about a lot of the stuff that's happening at the federal level and how it's impacting education.
Oh, really? Like what?
Like what? So, we wanted to bring a little bit of attention today to what's happening sort of in response to everything that we've talked about, right?
Right.
And
because the responses don't often get the same bandwidth from the public, but, they're, I would say, more important because this is going to determine how these issues that we've been talking about are actually going to resolve. Right. And how they're going to play out and what they're actually going to look like in practice, because so much of what the administration doing is in a lot of ways pushing the boundaries of its authority. And so a lot of it isn't going to go anywhere other than to make headlines, and the resolutions never seem to make the news in the same way.
Well, and I think one of the reasons why, this is the game, everybody, this is how this works. Somebody does something and then somebody else says, wait a second, I don't think you can do that. And they challenge it legally. And then all of the intricacies kind of play out in the courts. Right. And what ends up happening is, the courts either say, yeah, you can do that. No, you can't do it. Or what's more likely to happen is they come back and they say, all right, you can kind of do this, but you can't do that. And it gets really kind of nuanced.
It does. And you need someone to help you navigate all that.
And that's what we're here for, everybody. Look at that. Yeah, so today we just wanted to bring attention to the fact that if we have talked about it on this show in the last like 3 months, right, there is probably a corresponding lawsuit to counter that thing. And one of the things we wanted to do today was call attention to Brooke Schultz, who writes for EdWeek. And we've talked about EdWeek a lot on this show. It's a great resource, news resource for education issues. You know, Mark Walsh, who's been on the show a number of times, writes the Supreme Court and a lot of legal columns for EdWeek. But this article is by Brooke Schultz. It came out on March 26th. It was updated on April 10th. We are recording this episode on April 11th. So my guess is by the time this thing comes out, you know, everything
will have been updated about a couple more times.
Exactly. Yeah. And hey, now June me is here interrupting April me with an update. Like April me just said, we recorded this episode a while back, and now I'm back throwing in a little update as of June 1st. We decided to scrap the details of the bell ringer we recorded back in April because, like we predicted, this awesome article that Brooke Schultz put together has indeed been updated. All I will say now is check it out. We've put the link to the article in the show notes, but this article is tracking all of the lawsuits that have popped up in response to the various actions that the administration has taken with respect to education. So, like, there were 22 lawsuits or so in April, and now there's like 38. But if you check out the EdWeek article, they do a great job of breaking down each of the lawsuits, and they have a really nice color coding system telling you where each lawsuit currently stands. So check it out, everybody. We will keep you posted about all of these things on the show, of course, but we just thought that in today's bell ringer that we would share this resource with you because it was such a cool thing for us to see as education law geeks. So that's our bell ringer for today. Okay, now back to April me. You ready to dive into today's case? This is an interesting one, everybody.
This is a hard one. It's just because of like the situation.
We don't want to poke fun at this. It's incredibly unfortunate. These are people's lives, right? And you know, and again, the reason why we're doing this show is to hopefully ensure that teachers, administrators, schools, students, that like everybody is able to, parents, everybody is able to navigate this system in productive, responsible, and, you know, legal ways, right?
Right. Yeah. And to feel more confident in doing so, right?
Exactly.
Like that's such a huge piece of this where we want to demystify the law.
Right. And, you know, and as unfortunate as it is to have had so many people who have had to sort of go through these really unfortunate situations that can be life altering, right?
For sure.
You know, our hope is that we can all kind of look at these things and learn from them, right?
Right.
So here we go. You ready?
I am ready.
Excellent. So we've got Wyatt Erling. He was hired in 2004 as a second grade teacher in Lincoln County. Okay. Which is, where are we? In Missouri?
Wyoming.
Right.
Yeah. I think we are in southwest Wyoming.
Okay.
Which I don't know what's in southwest Wyoming.
Lincoln County.
Hey.
Dad jokes aplenty. All right. So he was hired as a second grade teacher in 2004, so just over 20 years ago. And when he was first hired, the district issued him an Apple laptop. All right.
Ooh.
Okay. Very nice. Common practice. All right. You get hired by a school district and you are issued school devices.
Yeah.
Okay. He created an Apple ID using his district email. That's kind of like a little red flaggy to me.
I was going to say the first warning bell just went off.
Yeah. Like all of a sudden you got a district device and you're creating what is, you know, what I would argue would be kind of like a district account because you are using the district email address. Anyway, you know, we don't need to dive into all of that. But the point is he created an Apple ID and he uses his district email to do so. And he continued to use that same Apple ID on both personal and district issued devices for the next 15 years.
Yeah. So like, second warning bell, right? If he hadn't used the Apple ID on his personal device, but like, I get it, right? You create a login and you just use the login anytime you get a new Apple product and it syncs everything magically. And I don't understand how any of it works. And so like, I get it. I'm with
totally get it. I totally get it. And we're talking about it now,
which means it's probably not what you should do.
Right. And we're kind of talking about it as though like we know this is something that you shouldn't do. And listen, as education law professors, as former school administrators, all that stuff, we've talked about all this stuff enough to basically say we know this is not something to do. But to your point, Chris, like this is not an uncommon thing.
Right.
All right.
Right.
And and I wouldn't be surprised if a lot of people who are listening to this right now probably fall into this category, and we don't blame you. Like this is it. This is very easy to do without kind of thinking about it, right?
And so, Jamie, let's talk about why it might not be the best idea.
Okay, so a number of years later, we're in the 2018-2019 school year. Erling has been teaching here in Lincoln County for like 14 years at this point. He constantly received good evaluations of his teaching. He had no performance or disciplinary issues. According to the superintendent, he was, quote, the kind of person and teacher that he would have wanted to continue working in the district.
Okay. So 14 years, things are going really well, it sounds like.
Going well. And listen, as a former school administrator, having male teachers in the elementary classroom is, that's a great thing too. Anyway, between 2004 and 2018, obviously technology changed quite a bit, right? I bet his laptop got smaller. His laptop got smaller. His phone likely became much more versatile because, as you might know, the iPhone didn't even come out until 2007. And I remember that because that was my first year as a principal and things changed.
I bet things got interesting
when that iPhone came out. So he started there in 2004. There was no iPhone. Like, people were probably on Blackberries and flip phones and stuff like that at the time. Yeah. And so like, when you had to text, you had to hit the 8 4 times, right? Like picture quality on the phones back then was, was not great. So people didn't use it. Like we just use technology now and what we have available to us. It's so different than what it was in 2004. Anyway,
and there's a steep learning curve.
Totally. Yeah. So at this point in 2018, Erling now has a whole bunch of district issued Apple products. Okay. He's got a classroom set of iPads for his students. He's got a laptop that he used to teach in the classroom. He's got outdated iPads that he kept at home. He's also got a personal iPhone.
Hey, that Apple marketing had been working, I guess.
Yes. He's bought into the ecosystem.
Well, once you get in, it's hard to get out.
That's right. It's like The Godfather, right? Which I think some people.
My heart, Fredo.
Yeah. So at this point, he's got a whole bunch of Apple devices, right? And as we said, he's using this Apple ID, and many of you might be aware of this. Some of you might not be aware of this, but if you're using the same Apple ID on everything, there's a lot of capability to sync various features and information and whatever across devices. All right. And a lot of those settings are sort of automatic, and a lot of those things you have to go in and you got to be kind of tech savvy to know how to manipulate all that.
You got to turn them off. Right. Because the default is, for many of these things, is to share everything.
Right.
Yeah.
And,
so and if you don't know that.
Yeah, you don't know that. And when you go to set up these new devices, like it asks you 400 questions as you're setting these things
up. I just
want
to play with my new toy.
Yeah.
Let's
and
go.
if you're not paying attention, you're just clicking, okay. Right?
Yep.
So in March 2019, the superintendent, Matt Erickson, got a call. And the call was from the Wyoming Department of Family Services. All right.
Okay.
Yeah. And so this person at the Department of Family Services said that they had gotten a call from Erling's ex-wife indicating that there might be inappropriate, pornographic, and sexually explicit images stored on a district-issued iPad that was issued to Erling. Okay? And indicated that the ex-wife and their 2 children may have seen those images.
Okay. Yeah. And I think we're starting to see where the trouble might be coming.
The superintendent then getting into his car and driving straight to the school.
Right. Yeah. Because that is not a concern you ignore, right? As a school leader.
No. And he didn't even pick up the phone. He just got into his car, according to the court report here. He got into his car and he drove straight to the school, told the principal. They called Erling to the office. The superintendent asked Erling where the iPad was. He said it was at his house. So then, this is the other thing that's funny. All 3 of them, the superintendent, the principal, and Erling, jumped into the car. I don't know whose car. Probably the superintendent's, maybe. I don't know. And drove straight to Erling's house to get the iPad. So they are going all in on taking care of this right away.
Hey, I appreciate the taking care of it right away. Yeah, because it is a serious allegation, right? Hey, there's inappropriate material on a district device. We don't know where it is. We don't know who has access to it.
Right.
We need to get to the bottom of this, immediately proactive.
And maybe the superintendent doesn't want to send Erling home to get it himself for fear of deleting the evidence or whatever.
Spoliation of evidence. Right. Yeah. I also just love the idea of all 3 of them in a car. That must have been an awkward
drive. That was an awkward drive. I would assume.
Hey, although, can someone turn the radio on?
So again, you never know. The superintendent did say that this guy had glowing, teaching evals and things like that. Maybe there was a great relationship between the principal and Erling, and
he'd been there for 14 years, right?
Right. And maybe people are not approaching this. Maybe this car ride wasn't awkward, but maybe it was uncomfortable. And because, hey, we've got a great teacher here who might have screwed up, and that could be bad for everybody.
Right.
And people like this teacher. It's not like we're doing a lot of speculating now because this is the kind of stuff that isn't included in the court report. But
it's not a legally relevant fact, if you will.
No, it's not legally relevant, but we have to acknowledge that there's a lot of stuff at play here that doesn't make it into these court reports.
Right. Which highlights something that you and I talk about a lot, which is these cases, one of the most important things, sure, there's the law, but there's also the people and their relationships and how those play out within these things. So
huge.
I think this is one of those situations where I applaud the quick and decisive action of the school leader. We'll talk about how that all plays out later, but so far, so good.
Yeah. And, I only mention all of this just because it's important to, we're coming at this, sort of in hindsight. All of this stuff has happened. We know.
It's very true.
We know that basically a teacher got in trouble for doing something that they shouldn't have done, knowingly, unknowingly, whatever. But we can't lose sight of we don't want to paint the picture that this is a terrible person with horrible judgment, because it's people make mistakes, right? And, we're trying to prevent people from making mistakes, you know, on the show. But I
don't even know if you can call it a mistake if you didn't know it was happening. But I think we're going to have ourselves, Jamie.
And we are, and we've had an episode on that too.
The knife episode.
The knife
Warren
episode.
Versus Seal.
Yeah. You can't you can't get in
expel
trouble
a kid for a knife
for violating a rule that they didn't know they were violating.
Uh-huh.
All right. So they go to the house, they get the iPad, the superintendent, along with the help of the district's IT department, they review the iPad's contents. The superintendent found 1,000 images, and most of which were completely fine. Standard, innocuous, not inappropriate kinds of images, blah, blah, blah. But there were about 50 pictures that the superintendent had a problem with, right? And the superintendent described those pictures as, quote, graphic, pornographic, sexually explicit, obscene, and inappropriate for a district device. So he, unquote, pretty much used every adjective.
I was going to say, that's a pretty
that's an extensive
list.
Yeah, that's an extensive list.
Okay. So there's So there's pictures on the iPad
Yeah.
that
were sexually explicit. Inappropriate.
Right. And they, in the pictures, these were pictures of Erling, right? Like,
yes, I believe so. Yeah. There were pictures of Erling, and
these were personal pictures.
Personal pictures
okay.
that were sexually explicit of him, and I think his then girlfriend was involved or something. Now, Erling had no idea what was going on. Like, after they got the iPad and the superintendent took it, Erling had no idea what was happening.
Right. He just had to drive to his house with the superintendent and his principal to get the iPad. Like, he knows something's going on, but like...
Yeah, he doesn't know what. So he asks his kids if they had seen anything on the iPad that might be problematic. And one of his kids replied that they had seen a picture of Erling and his girlfriend, who he later married, on vacation in Mexico. What they were doing... How did that
get there?
It didn't say in the court report what that picture was of, other than him and his girlfriend in Mexico. But when Erling asked his kid, is there anything that could be objectionable? And the kid pointed to that photo. Chances are it was that photo that had some sexually explicit stuff.
Right. But if you're Erling, you got to be thinking, oh, crap.
Yeah. Because he knows what pictures were taken. Yeah.
Right. And how did it end up on the iPad? Like, I didn't take the iPad with me to Mexico.
Right.
I took my iPhone with me to Mexico.
Yeah.
And so, like, you got to imagine just like the gut sinking feeling of like, oh, crap, my photos from here are on there.
Yeah. Yeah. And so now, like, he's probably in his head, like, everything's kind of unraveling, right? Like,
right. Yeah.
Yeah. He's having that oh crap moment. So at the end of March, the superintendent called Erling in for a meeting. At the meeting, the superintendent provided Erling with a letter that outlined the initial findings of the investigation and included that they had found inappropriate material on the iPad.
Right.
All right. So Erling explained his side of the story, that he kept the iPad at home. It was a backup. He never took it to school. He never used it to teach. Remember, this was like outdated iPads. He had a classroom set, but he took some outdated ones home. He said he never used it to teach. He said he was completely unaware that any personal photos from his iPhone were being used or shared on the iPad.
Right.
Okay,
And this was some really, important mitigating circumstances, right? Like,
he had
this
no
is
clue.
a device that is only at home.
Mm-hmm.
No one else has access to it. It doesn't come to school, so there's no risk of students seeing it.
Yes.
And like, Erling didn't do anything to get the photos from his personal device to his school device.
No, it was happening automatically without his knowledge. One of my questions right now is if he's got this Apple ID associated with all of these school devices, then what is to prevent those pictures from ending up on a device that does make its way into the classroom?
Right.
If they're all using the same Apple ID.
And that's not something that got addressed, but like, I imagine that was part of the investigation too. But like, the chances are that the classroom set of iPads doesn't use his, right? But like, maybe his laptop does, but
maybe his laptop.
Again, it's one of those things where you're like, maybe that setting just wasn't automatically turned on.
Right.
I got to assume they investigated that. And if it's not part of the record, then it doesn't seem like it's an issue.
Right.
But no, I had the same question.
Yeah. So, it's important to note that when Erling was explaining his side of the story, he was very remorseful. He was emotional. He was embarrassed.
Can you imagine?
Like this
right?
is
like how
it goes back to our point about this as being,
right?
These are people, right?
Right. Yeah. And your boss just saw you in situations you wouldn't want your boss to see you in.
Exactly. So after that meeting, the superintendent placed Erling on administrative leave and, said we need to investigate this fully. It was a quick investigation because basically by early April, so, just a few weeks later,
maybe, if that.
Yeah, they decided to terminate Erling's contract.
Okay.
Yeah. So that notice of termination included the following. It said that Erling had caused or allowed pornographic materials to be placed or stored on the district device.
Okay.
It said that Erling had violated the district employee acceptable use of technology procedure policy. It said that he had violated the district's authorized use of district-owned materials and equipment procedures.
Okay.
And it said that his actions, quote, constituted immorality, placed students and staff at risk, and was harmful to the educational process. Okay.
All right. I'm already picking up on some issues here.
Yeah.
One, like caused or allowed. That's tricky because it happened automatically without him knowing about it.
Yeah.
Right?
And caused or allowed kind of implies a knowledge of or
Or
an awareness, intent.
Yeah.
Right? So
At
that's
the very least awareness, if not intent. Yeah.
Yeah.
And then like this
immorality
thing, like, are they saying that it's immoral to have these pictures on school-owned devices?
Or were they attacking the actions,
like the
in
fact
the
that he
pictures?
took those pictures in the first place,
or
you know,
the content
conduct
of the pictures, right?
Right. I got to imagine it's the on school devices thing, because otherwise, well, and you know, not to get too far ahead of ourselves, but like the immorality thing kind of gets dropped here in a second. But like, if it was the fact of the pictures and what they showed, like that opens up a whole different can of worms, because the school, like, you know, we know that school employees have rights to privacy, and school authority over that kind of private conduct is much more limited. So like, you know, district-owned devices, much clearer line there.
Absolutely. So the end result of that letter was that all of these actions were grounds for termination and under Wyoming law, and the superintendent was going to recommend that the board terminate Erling's contract.
Okay. Yeah. And that letter is doing a lot of legal heavy lifting.
Well, it's it's like the whole legal case.
Well,
right?
and it's the notice that kind of gets this legal ball rolling, right? Like, because, you know, Jamie, you and I have talked about employment issues a couple of times now, but one of the most important things about employment law in the education context is procedure. And so much of procedure and kind of the protections for school employees is laid out in state statute. And they outline exactly like the steps you have to go through in order to discipline or dismiss a teacher. And so like under Wyoming law, this is kind of the first step in that dismissal process. You have to provide a letter to the teacher with written reasons in support of the employment decision. You know, under law, you can provide lots and lots of reasons. But the reason you have to do this is because teachers, and again, all of this depends on state law, so every state's a little bit different, but teachers have employment contracts with their districts. And during the term of the contract, which usually is like school year to school year, right?
Right.
Unless you've got tenure or a continuing contract, in which case it just kind of continues. Like during the life of the contract, you, the teacher, are bound to fulfill the obligations of the contract, but so is the district.
Yes.
And so typically state law will say you can't end a teacher's contract during the life of the contract, except for very specific reasons. And, you know, under Wyoming law, at least, the reasons, well, actually, you know what? Here's the reasons. You can end a contract or non-renew a teacher. So basically not rehire them at the end of each contract between each school year. If they've got a continuing contract and, you know, they've got some expectation of continued employment, you can dismiss them or discipline them for, you ready?
This is under Wyoming law we're talking
Wyoming
about.
law. Yeah. But this list is like,
it's pretty
typical.
It's pretty
right?
typical.
Like there's nothing here that is out of the ordinary. That every state's going to have different flavors of this, but it's all going to be pretty
universal,
on par with this. So like incompetency. Yeah, no, that's good. I want to be able to get rid of teachers who are incompetent.
Yes.
Neglect of duty. So not doing what you're supposed to do. Immorality. And we'll talk about that one a little bit more. Insubordination. Physical incapacity to perform the job duties, even with reasonable accommodations. Failure to perform duties in a satisfactory manner. Sounds a little bit like incompetence. Conviction of a felony. Okay. Yeah. No.
Okay.
Tracks. And this is the big one for Wyoming. It's their catch-all. Any other good or just cause related to the educational process.
That's interesting.
Yeah. And good cause or just cause is typically kind of a catch-all that most states have for when you're allowed to dismiss a teacher or discipline a teacher during a contract. But, you know, what that means is very, very specific to each state.
Yeah.
Even though they all have very, you know, similar categories like the ones I just read.
And just as a side note, it's probably important to point out here that most states do have very similar language that basically says you can terminate a teacher if they are incompetent, if they are neglecting their duty, if they are insubordinate, if they can't perform their duties. Like that, those are very common things. And there is a perception among many in the education world that there are some not great teachers out there and we never do anything about it, right? And a lot of people think it's because they can't. And the reality is, there's just a few things I'll say about this. Yeah, generally the law says you can. That's one really important thing.
It just tells you how you can do it.
It tells you how you can do it.
Follow what it says.
Yeah, the other thing is like it's a lot easier to not renew a teacher's contract than it is to terminate them in the middle of a contract because in most of those cases, teachers have more due process rights if they're terminated versus if their contract is just not renewed.
Right. Unless they have a continuing contract or teacher tenure, in which case, they've got an expectation of
due
renewal.
process.
But if they're year to year, then you can non-renew them for any reason, no reason, as long as it's not an illegal reason.
Right. Yeah. You can't not renew them because they're not a race that you want to have employed at your school. You can't renew them because they're pregnant.
You did that, you'd be on a Chalk and Gavel episode.
That's right. So, which is actually really funny because there's a case that I teach when I cover wrongful termination and stuff like that in my classes. There's another case that is about a teacher who is terminated for reasons that you can't terminate a teacher for, like the school didn't like where she lived and the fact that she didn't go to church and, stuff like that. And the fascinating thing is, I think that case is also out of Lincoln County, Wyoming.
Well, and this cannot be a big county, right?
I don't think so.
Yeah, okay.
I mean, there's definitely a number of years, decades in between these cases.
Right.
But anyway, it's just important to note that, that schools can do this, but there's a lot of, there can often be a lot of complicating factors.
And the flip side of all that is that employees have, really important job protections, right? And so there's very specific procedures that have to be go through because we want to ensure that, Jamie, to your point, we don't make decisions about teachers and public employees for illegitimate reasons, right? We want it all to be based on what they're doing, why they're doing it, which is why procedure is so important. It's why documentation is so important. If you've got concerns about teacher performance, document, because if you think someday you're going to go down this road, you got to have the receipts, right? And so
that's why a lot of people don't go down that road when they should, is because they haven't done their due diligence to document the issues.
Right. Yeah.
Okay. So he has this administrative hearing.
And this is part of his due process rights.
Yes.
So the law says, once you get this notice of termination, you, the employee, have a right to request a hearing. And the hearing is from the Wyoming Office of Administrative Hearing. So it's a state agency that is hearing this dispute before the school board can act on the termination or the dismissal letter.
Right. So at that hearing, he was contesting whether or not the superintendent had proved that there were sufficient grounds to terminate. Okay. Did the superintendent have enough here? Okay.
Right.
Specifically calling attention to this immorality thing.
Allegations of immorality, right? Because that was one of the reasons the superintendent said, we're going to dismiss you, is because of this immoral conduct.
Yeah, exactly. So a lot of witnesses show up here. Two of the witnesses explained the number of ways that the photos could have ended up on the iPad. So we've got these technical witnesses here.
Yeah, which makes me so happy just imagining that. You and I have joked about the Supreme Court and emojis, but anytime you have to explain technology to a court, I just something about that is charming to me, I guess. Quaint, maybe? I don't know.
Anyway, they talked about all these different ways that these pictures could have ended up on the iPad. They talked about the sync setting and how it was active when the superintendent received the iPad. So basically, the setting was active when they got the iPad.
Which is very strong evidence of how those images got onto the iPad.
Exactly.
Yeah.
Other witnesses testified about the district's technology policies. The superintendent called them acceptable use policies.
Yeah. I mean,
which
most
is
people have
normal.
something like that. Yeah.
Yeah, that's normal. So, one of those, those policies talks about how district devices should only be used for district activities, that any personal use must conform to district policies. Employees don't have any expectation of privacy on those particular devices, things like that, right?
Yeah. And those are all really standard
Very standard, very
concepts. Yeah.
Yeah. These policies also required that all communication on district devices be, quote, responsible, efficient, ethical, and legal.
Good. I appreciate that.
Yes.
I also love the idea of efficient because, like, if that's in the policy, I'm copying, pasting that policy. And anytime I get an email that's just too long.
Yeah, I would say, sorry, the district requires that I can't respond to all this.
Yeah. I'm sorry. Please review district policy 472 on the efficient use of communication.
Yeah. My answer is no.
Can you imagine? I would love it.
That's funny. Anyway, also said if district employees encountered obscene or pornographic material on the device, they were to immediately report it. Finally, the policy said that, quote, employees shall not access, post, submit, publish, or display harmful or inappropriate matter that is threatening, obscene, disruptive, sexually explicit, or that could be construed as harassment or disparagement of others. Sounds like a lawyer wrote that.
Yeah, no. And my lawyer spidey senses just went off the chart because I think that list of words is really important. It's really interesting because, like, that feels like what he's being accused of violating. But, like, to your point, Jamie, like, there's a reason lawyers list all of the verbs.
Yeah.
Right?
As a catch-all. Yeah.
Right. But, like, what Erling did doesn't fit any of those verbs, right? Like,
he didn't access
it. He didn't post it. He didn't submit it.
No.
He didn't publish it. He didn't display it. All he did was
take it on a personal device. That's all he did.
Negligently, at the very most, like unknowingly, it got synced or transferred. Correct. Or like, but it wasn't a affirmative act from him. So I'm starting to see maybe what some of the arguments are going to be.
Yeah.
Here.
Because all of those verbs are kind of intent related verbs.
Right. Or they require some kind of affirmative action from the employee, right?
Yeah. Which he didn't really do here.
Right.
So after the hearing, the hearing examiner, basically the judge, Light, I guess.
The diet judge.
The diet judge. Right? I'm sure if there's a hearing examiner listening to this, they're really upset right now. Because that's not how they want to be.
It's a very serious job.
They don't want to be described as a diet judge.
That's true. Let's call the process diet court. They're a real judge.
So after the hearing, the examiner issued his recommendation and sent all that stuff to the board. His recommendation, his reasoning, all of that stuff, it all went to the board. And he recommended that the board reject the superintendent's recommendation to terminate.
Ooh, okay.
Yeah.
So superintendent said, I'm going to terminate you. And the hearing examiner said, nope.
Yeah. Said,
I don't think you've got enough.
Yeah. And so here's what he said. He said that there was no risk to students or the educational process. He said that the existing policy did not cover the means by which the images were transferred to the iPad.
Which was my point about the language.
Yeah. It's the hole in the policy.
Yeah.
Right. And according to the hearing examiner, the superintendent failed to demonstrate immorality or good or just cause to terminate Erling.
Okay, so there wasn't enough evidence and it didn't fit under the policy.
Yeah.
All right. Okay.
You think we're done? There's more.
But wait, there's more.
So the board declined to accept the hearing examiner's recommendation.
Always a good place to be.
I know. It's fun that we have all these processes and then they're like, I'm just going to do whatever I want.
Right. Like, thank you for doing that really long hearing with all those witnesses, but I don't want to.
I reject your reality and substitute my own.
Exactly.
What was that from? I can't remember. Anyway, so the board recommended that Mr. Erling be dismissed for good or just cause. And interestingly here, the board did not address the superintendent's alternative ground for dismissal, the immorality thing. So they didn't even talk about that.
Yeah.
So they just said, we've got cause to terminate him.
Right. And that's because, like, the district use policy seems to be their strongest argument, because I think immorality would be even more attenuated.
Yeah. So according to the board, the district's policies were intended to prevent harmful or inappropriate material on school-issued devices. Okay, so they're basically saying, listen, the intent of the policy was this, and he violated that.
Okay.
And
it didn't matter how they got there, just the fact that they were there.
Yeah, exactly.
Okay.
They also concluded that the policies didn't require intent at all or any affirmative act by the user, even though the policy essentially required intent based on the language that it used.
Yeah.
Right?
I'm skeptical. Because if you want it to cover unintentional acts, then you can just say either shared it, blah, 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 or caused it to be.
Yeah. Well, caused is also another kind of act.
Yeah, but the caused here, if you want to go down a rabbit hole, is I activated a personal iPhone with the same Apple ID.
That's
so
the cause,
I did take an affirmative action that caused it to happen.
Yes.
Even if I didn't intend the thing that actually happened, I still took an affirmative act that caused the thing. So
interesting.
Sorry, lawyer Chris is coming out.
Okay. Hi, nice to see you.
Hi. Yeah, no, I would have written a different policy.
Welcome to the show.
Hey, good to be here.
Yeah. So basically, the board went on to conclude that Erling's violation of the policies did cause harm to the educational process by putting students at risk of seeing inappropriate images. This is interesting because the hearing examiner concluded the exact opposite.
Right. Yeah.
And finally, the board concluded that the violation had reasonable relationship with Erling's fitness and capacity to serve as a teacher because his conduct created a risk of harm to students and staff. What conduct they were referring to? The acts that were depicted in the pictures themselves, the syncing, they're just basically saying what he did speaks to his fitness and capacity as a teacher. And that to me is
that feels
that's
flimsy.
A stretch.
Yeah.
That's a stretch.
Right? Because
you know what? If you're going to ignore the hearing examiner's recommendations and do something completely opposite, my advice would be keep it simple. Don't keep talking. Enough.
Right. Yeah. But if you, under Wyoming law, interestingly, if the school board doesn't follow the hearing examiner's recommendation, they have to provide written reasons why they didn't. So the law.
I'm just saying, be careful with those reasons and make them simple and make them a little bit more ironclad.
Yeah. Well, and I think that's the issue here, is that it's not ironclad.
Yeah.
And it kind of begs the question, how did we get here? Right. I think there's a lot of different ways.
That trip to Mexico is how we got here. Sorry.
There's a lot of different ways that this could have gone, though, right? It could have just been the principal saying, wow, I'm glad we caught this before anybody else saw it. Let's fix it. I'm going to revise my policy. I'm going to get Erling to, change his settings. And I'm going to create a district policy where hey, maybe I make you an Apple ID and I tell you can't use this on any other device. There was so many different ways to handle this that aren't going to that blunt, this teacher no longer works here.
And I don't see why not. I don't see why that couldn't have happened. And even if you wanted to put something in Erling's file. Yeah.
A letter of reprimand or even just something like that.
Totally.
That would be so simple.
And it could acknowledge the fact that, he was remorseful, he was embarrassed, he was unaware that this was what was happening. He made every effort to remedy the situation. We know for a fact that none of this stuff ended up on any devices that were in school, that were, that students had access to. And so it's almost like listen, no harm, no foul.
Yeah. And I think that that's, if I were the school leader, that's kind of where I would fall.
Yeah.
And as everyone does on Chalk and Gavel, this isn't the end of the story, because Earl files a lawsuit challenging his dismissal. Right. And, I feel like we've kind of already tipped our hand, but the school district doesn't fare very well in this lawsuit.
No.
So Erling challenges his dismissal. He basically has two arguments. One is that the district's policy doesn't cover his situation. Mm-hmm. And then the second argument is that there's no connection between his actions or inactions and getting the photos to the iPad. There's no connection there between what he did and his fitness or capacity to be an effective teacher.
Right.
And that's his argument. And so he files this in Wyoming State Court, because this is all based on Wyoming state law. And the trial court agrees with Erling. The trial court reverses the board's decision to dismiss Erling and concludes the board's interpretation and their policies were contrary to their plain meaning, and that there was substantial evidence that did not support the board's decision that Erling couldn't be an effective teacher.
Right.
So Erling now is 2-0 when it comes to outside people looking at his case. The board, though, appeals that decision to the Supreme Court of Wyoming.
Okay.
So we are at the highest court in Wyoming. And the Supreme Court's review here is actually pretty limited because this is an administrative appeal from a decision of a lower agency. Courts are kind of limited in how they can look at that because we don't want courts to like second guess agency decision making. So the Supreme Court can only really look at whether the decision was arbitrary, capricious, an abuse of discretion, or if it was unsupported by substantial evidence.
Okay.
So, was it just completely out of left field, or did you not have enough to justify your decision? Those are really the only things the court can look at to overturn the decision of the school board here. But spoiler alert, the court here finds that the board's decision violated both of those ideas. It was arbitrary and it was unsupported by substantial evidence. The Supreme Court says Erling's conduct wasn't covered by the policy. And because you didn't have a policy, he couldn't have had any idea about how to conform his conduct to your expectations.
Yes.
And so because he couldn't conform his conduct to your expectations because the policy didn't cover what he did,
then it's arbitrary.
That is out of left field. Yeah. So like the Supreme Court starts by kind of articulating what good and just cause means, or good or just cause means when it comes to dismissing teachers. And they say that in order to articulate good or just cause, you have to provide the teacher with clear standards of conduct so that they can conform their actions to them. And the violation or the thing that the teacher is accused of doing has to really call into question their ability to be an effective teacher. Like, does it speak to their ability to do their job?
Right.
And so, looking at both of those questions, the court says for that first one, you didn't give clear standards of conduct because this policy doesn't cover what happened.
Right.
Which, I think is really interesting because, Jamie, you mentioned the intent of the policy, right? The intent was very much there, but similarly, like,
according to the board, that was the intent.
Yeah. And like these reasonable use policies all kind of have the same gist to them. Yeah. But like there was also no intent for Erling, which I think is the really, really crucial bit here. So like when it was looking at the policy, the court said that, nothing in the policies prohibits teachers from using the same Apple ID on personal and district devices, which hopefully they changed that now.
Yeah.
And it also, the policies didn't inform teachers that they could be disciplined for inappropriate material that they didn't put there.
Yeah.
Was just
going there.
synced automatically without their knowledge from a personal device to a district device. Mm-hmm. And there was nothing in the district policies that said staff could be punished for the mere existence of inappropriate material on their devices, regardless of how it got there.
Right.
Nothing, like the policy didn't address any of that because of the language we just read. Mm-hmm. So because of that, the court says the policy here doesn't cover what you did. So it was an arbitrary decision. But wait, that's not all.
Oh,
I know, I get to do it. They also said that there wasn't a reasonable relationship, or that there was substantial evidence, or like it was against the manifest weight of the evidence to say that this bared any relationship to Erling's ability to teach.
Okay.
Right. And so again, this is even with the significant deference that courts give to schools. And we've talked about that a lot. Like courts aren't going to second guess schools. So, the standard here the court has to meet is, was it clearly contrary to the overwhelming weight of the evidence that the board got it wrong? And they say yes, because if you're looking to dismiss a teacher for alleged immorality, unprofessional conduct, or moral turpitude, like that makes them unfit to teach, that's a really contextual analysis. You have to look at what happened. You have to look at when it happened, how it happened, why the person did what they did, how they reacted to it, and how it's going to impact the teacher's relationship with students, teachers, families, administrators, the community moving forward. Like that's a really contextual analysis. And here, like everything shows that Earl was, one, this was a complete accident. He was incredibly remorseful and embarrassed by the whole situation. And he didn't do anything affirmative. And as soon as he knew about it, like that was the end of it. And the other thing about this is like these iPads were kept at home. So there was no real chance that students would see these iPads, and early even testifying, like if I brought them to school, it would be after I factory wiped them to turn them in. And, if you're turning something in, they all get factory reset anyway. So like there's no chance that after he turns it in, it's going to ever sync or resync with his account.
Right.
So the court says, look, this doesn't mean Erlang's not going to be a good teacher, continue to be a good teacher moving forward.
So what happened?
The court said, nope.
You can't do that, school.
You can't do that, school. They said what you did was against the overwhelming evidence. And this is a tricky sentence. They affirmed the lower court's reversal of the school board's dismissal of Erlang.
Yeah, these are the parts of the law that like I have to read the sentence 12 times and draw a little map.
I mean, I guess if you want to get really technical, the Supreme Court affirmed the trial court's reversal of the board's reversal of the hearing officer's recommendation. Did I lose you?
It's like a quintuple negative or something.
Right.
Yeah.
Bottom line is the court says the board shouldn't have dismissed Erlang because they didn't have good or just cause.
Yeah. That's what much better. Well said.
Thank you. Yeah. See? Lawyers can talk simply. I prefer precision, Jamie.
Yes, exactly. So like I don't want one of the big takeaways to be like, go take whatever pictures you want on your personal iPhone and don't worry about anything. This case, even though the school got it wrong, this case should help illustrate how complex and problematic technology can be if it is, I don't want to say improperly used, but like if it is not completely well understood, like all the functionality of it, you've got to be very, very careful. And that's one of the reasons why some of these policies are like that we see are things that go to the extreme, like stay off social media and don't do this and don't do that.
Right.
And those are potentially problematic policies.
Well, and those are really problematic.
Yeah.
If we,
because you're suppressing
obviously every state is going to be different, but like that good or just cause and like the lines that school districts have to draw when it comes to regulating teachers' conduct out of schools, like if it doesn't bear a relationship to their ability to be an effective teacher, then like that's where schools have authority. As soon as you cross that line, it's like calling into question your ability to teach, like maybe schools can get involved, but like otherwise, this case is one of those examples of like hands off.
Yeah. Yeah. So, I mean, like, be careful, know how to use the technology that you're given if you're going to be using it sort of outside of how you've been instructed to use it, I guess, or what it's for.
Or don't do that.
Or don't do that. One of the other big takeaways is, we talked about this with the principal, like, were there other ways that this could have been resolved because we know students were not affected by this and so on, so that's something that we would really want administrators to kind of consider when you're confronted with these kinds of situations. And then from a district and policy perspective, right? Like if you want to capture everything, if you've got a particular intent, like, go ahead and make sure that your policies are ironclad. Because this one was
six more verbs to that list.
Yeah, exactly. And then, from a teacher, the last thing sort of from a teacher and administrator perspective is, and we've said this so many times on this show, know your policies. Know your district policies, know the state law, around this stuff, know that stuff.
Yeah. Or if you find yourself in a situation where your, legal spidey senses are going off. Talk to someone who does.
Yes, exactly. All right. Good stuff. What's our homework?
Your homework is to cause Chalk and Gavel to be liked on your favorite podcast platform.
That requires affirmative action on your part, everybody.
Well, as long as it ends up being liked, rated, or reviewed.
We don't care how it happens.
You know what? Let's make sure this policy is inclusive, Jamie.
That's right.
Find us on social media at Chalk and Gavel. You can also find our teaching guide at chalkandgavel.com. We would love it if you would engage with the show, share it with a friend, support us on Patreon, patreon.com/chalkandgavel. It means the absolute world to us to know that there are folks out there who find this valuable, and Jamie and I are going to keep doing it for as long as that is true.
Yep. All right. Well, that's it for this episode. We will see you again in 2 weeks. Have a good one, everybody.